Okay. So I was basically saying that low barrier, you either have to opt into low barrier or you can continue using your own custom criteria, with the only exceptions, of course, being that rent to income. You don't get to choose or change that. So all of the low barrier criteria are set forth on pages 10, 11, 12. It just, it's kind of low thresholds for financial requirements, low thresholds for criminal, low thresholds for rental history in terms of FED eviction cases. I want to throw out, I can't devolve into an SB 282 discussion, but the new law that was passed prohibits landlords from rejecting applicants for unpaid rent from April 2020 through February 2022 anyway. So at least for the next several years, you are not going to be able to reject any applicant just because they have unpaid rent from that time period anyway. Likewise, SB 282 prohibits you from rejecting for an eviction judgment based on a quote claim that arose between April 1 of 2020 and February 28th of 2022. So already, regardless of whether you adopt the low barrier, for the foreseeable future, you're essentially going to have to ignore unpaid rent and evictions from this lengthy, almost 2-year period. So keep that in mind. Information from references. That's severely limited if you adopt Portland's low barrier criteria. So if you don't want to use Portland's low barrier criteria, then don't. You can continue to use your own. And the only result of that is that you then have to conduct an individualized assessment of any basis on which you intend to deny the application before you issue a denial. Is everyone able to hear me? Thanks. Okay. And so what the heck is an individual assessment? Well, basically, it just means that you have to look at any supplemental evidence they provided. They may not have, but if they did, pursuant to your invitation in the application, that could be, a letter from their social worker, a letter from their priest, a letter from themselves, a certificate showing that they completed anger management. It could be whatever they think might be relevant to overcome some criteria of yours that they didn't meet. And this just says that you have to consider it. You have to use these factors like the nature and severity of the incidents, the number and type, the passage of time, the age they were. Now, all of that mostly makes sense, frankly, for criminal convictions. It's really hard to, use those factors when you're talking about a credit score or things like that. But this says that you have to do it and that you can still deny them, but you have to then in your adverse action letter, where you're telling them, okay, thanks for the supplemental info, but I'm still denying you. You really have to essentially explain why the supplemental evidence they provided did not adequately compensate for the criteria that they did not meet. So you have to kind of go above and beyond and say, here's what I considered, but it still doesn't do the trick because you still present a risk to safety or whatever your rationalization is. And RHA has a form, which is the PDX 7A, the supplemental notice of denial following individualized assessment. So that's exactly what you use that for, is you're going to use their normal adverse action letter, the PDS X6, as well as the supplemental notice of denial that's going to allow you to pencil in, okay, I considered all of these things that you provided, and here's why I'm still not accepting you. It's just an extra hurdle that you have to go through. You can't just write did not meet criteria, because that's not an individualized assessment. if they didn't provide supplemental evidence, then there's not a whole lot that you can say in your individualized assessment, other than why, articulating why you are rejecting them and that they did not provide supplemental evidence. All right, there's some disability related modification requests. I'll let you read over that on your own time. You are required to allow them to appeal for up to 30 days. You don't have to hold the unit to see whether they're going to do that. They have an opportunity to address whatever the negative information is. If they appeal successfully, you then have to pre-qualify them for all of your properties. If they have units at the same or lower rental rate for 3 months, you can't charge them another screening fee. And if any of those other units come up up for rent during those 3 months, you have to actually affirmatively reach out to this successful applicant appeal person and tell them and give them 48 hours to take that unit before you, open it up to the public. So it would be like before you advertised it to the public. Now, this doesn't require that you grant their appeal. It just requires that you allow them to do so. If you reject them after the appeal, it's all kind of irrelevant, but they have to have this opportunity to do it. One more point. If a financially responsible applicant qualifies, so they meet all your criteria, but they've applied with someone who is a non-applicant tenant, meaning someone who is not a financially responsible tenant, and that person does not qualify, which is generally going to mean that they probably have not met your criminal requirements, because again, you can't screen them for financial. You still have to accept the financially responsible applicant. You can't say, okay, because you applied with this non-applicant tenant who hasn't qualified, you're rejected too. Because essentially the rule is, think of it this way, if an individual applicant qualifies, you just have to accept them. You can't condition it on everybody who applied together qualifying. And so now you may be thinking, well, doesn't that just mean that they're going to just move in anyway, and I'm going to have an unauthorized occupant situation on my hands? And my answer to that is yes, that's probably what it means. But that is what FAIR requires. Do you have to go out of your way to again request supplemental information? No, you don't. You don't have to chase them down and hit the pause button. The only thing I will say, of course, is that there is a difference between supplemental information in general versus a request for accommodation. You might get a request for accommodation that you modify one of your criteria because of a disability related need. And if it's articulated in that manner, this has nothing to do with FAIR, it's a fair housing issue. There are certain requirements that you do have to consider and go through an interactive process to determine whether the Fair Housing Act would require you to modify your policy because of a disability related need. That's a bit beyond the scope of tonight's lecture, but I just want to put that bug in your ear so that if you receive a request for accommodation at the application stage, you understand that it's an important and serious thing. And if you're not entirely sure what to do with it, you'll want to get some advice because fair housing violations sting a lot. Okay, you got to tell them within 2 weeks whether they've qualified or not. We've already gone over the appeals period. So the final thing is, so what happens if you run afoul of any of these myriad requirements? Well, for this aspect of FAIR, it's $250 per violation, plus any actual damages. That would mean anything that they suffered out of pocket, and attorney fees and costs. It gives them a cause of action to sue you for all of those things. So, if it's one violation, it may not be massive, But if it's a number, it can start to rack up. And if it's a class action scenario where you just have some regular policy, like let's say that your application does not give the opportunity to indicate a mobility or disability or other disability status and doesn't include the PHB forms, and you've been doing that for a year, well, I mean, it's possible that, every applicant is a class member and they could all sue you, right? So it's all a matter of scale. And so your best bet is to minimize your liability by complying with all of these requirements, and all of the RHA forms that I discussed at least give you the template and the means to hit the mark on the vast majority of these requirements.